Hello viewers, I am Dr. Simranjeet Kaur, Professor and Principal, School of Law, City University, Ludhiana, Punjab. Welcome to this lecture on the Ronald Dworkin's Taking Rights Seriously with a focus on the model of rules and the hard cases. Dworkin's work is a revolution, legal and political philosophy by offering a compelling critique of the legal positivism and unique theory of the adjudication. By challenging the dominant theories of law, particularly H.L.A. Hart's concept of law, Dworkin introduced a framework that emphasized principle alongside rule in the legal reasoning, advocating for the judicial decisions rooted in the moral reasoning rather than merely policy consideration. This lecture aims to explore Dworkin's evolving critique of the legal positivism, the distinction between the rules and the principles, and the introduction of this mythical judge, Hercules, as a model for the judicial reasoning. By the end of this lecture, learners will be able to understand the foundational critiques Ronald Dworkin's presents against the legal positivism, differentiate between the rules and the principles in Dworkin's legal theory, analyze the role of the principles in resolving hard cases and the rejection of the judicial discretion, gain insights into the Dworkin's concept of Hercules and the idea of a law as a coherent body of the principle. After these lectures, participants will be able to explain the Dworkin's critique of Hart's rule of recognition and positivist model of rules, apply the distinction between the rules and the principles in analyzing judicial decisions, critically assess the implications of the Dworkin's theory of the modern jurisprudence, evaluate the compatibility of Dworkin's right-based thesis with the broader legal framework. So, let's start with this session. A landmark work of the political and the legal philosophy, Ronald Dworkin's Taking Rights Seriously was acclaimed as a major work on its first publication in year 1977 and remains profoundly influential in the 21st century. A forceful statement of the liberal principles championing the legal, moral, and the political rights of the individual against the state. Dworkin demolishes prevailing utilitarian and legal positivist approach to the jurisprudence. Developing his own theory of adjudication, he applies this to be the controversial public issues from civil disobedience to the positive discrimination. Elegantly written and cuttingly insightful, Taking Rights Seriously is one of the most important work of the public thought of the last 50 years. Ronald Dworkin has based his theory of law on his ongoing critique of the positivist theory of law, especially by the theory developed by the Hart in the concept of the law, as Dworkin believed that Hart's theory was the ruling theory of the law. Over the years, however, Dworkin's theory has evolved in the course of his response to the critiques of his work, or alternatively due to the fact that positivists, in response to his criticism, adapted the theory of positivism. From the 1916s onwards, this evolution of the anti-positivist theory can arguably said to have occurred in three phases. Dworkin is attempting to provide a systematic alternative to the legal positivism, which he described as the ruling theory of law. In particular, he attacks H.L.A. Hart's version of the legal positivism as articulated in the concept of law. Dworkin dubs positivism the models of the rules. According to the model of rules, there is a master rule, Hart's rule of recognition, which allows one to determine which rules of the legal system are valid. Because of the positivist instance on the separation of law and morality, the determination of validity of law is primarily a factual matter. Whether the particular rule meets the condition of the master rule of recognition, one has legal rights and the obligation when there are legal rules which provides them. If there are no legal rules available for a case, or if the available rules are inconsistent or vague, the judge will not have adequate legal standards for deciding the case. According to the model of rules, the law has run out at this point, and the judge has discretion to find extra legal materials on which to base the decision. When the law runs out, there is inadequate legal materials for determining a single right answer. So many answers would be legally acceptable. Dworkin rejects this model. He argues, in effect, that law never runs out. Dworkin argues that law is more than a set of rules. In his early work, he emphasized the role of principles in the law. If one has principle in the addition to the rules, the law cannot run out. Hence, there cannot be judicial discretion. Dworkin recognized that the introductions of the principle is not in itself adequate to counter the model of the rules. In later essays, especially hard cases, he develops a more elaborate theory of law. He introduced a mythical judge, Heraclius. Heraclius is to construct a set of principles that best explains and justify existing law. This theory will include a theory of the constitution, a theory of legislation, and a theory of the president. In order to develop a consistent theory, a theory of mistakes must be included. In fact, then Heraclius is to construct a set of principles that fits the institutional material, constitution, statutes, and the precedents. If more than one liberty fits the institutional material, Heraclius is to choose the one that most appeals to our theory of morality. Dworkin has devoted much attention to the role and justification of the judicial function. He distinguishes between the principles and the policies and maintains the judicial decisions should be generated by the principles rather than policies. Given the widespread belief that judges legislate, or more particularly that they make policy determinations in their decision making, Dworkin's claim may seem quite radical. But because he argues that the rights thesis and the principled basis for the decision are compatible with both consequentialist reasoning and the discussions of the issue in economic terms, the theory ultimately is not very radical. Counter-arguments to the Dworkin's theory must be framed very carefully if they are to be effective. Dworkin distinguishes between argument of the policy and the argument of principle. An argument of the policy justifies a political decision by showing that the decision advances or protects some collective goal of the community as a whole. An argument of the principle justifies a political decisions by showing that the decision respects or secure some individual or group rights. According to the Dworkin's argument of the policy are most appropriate in the legislatures. Judges should limit their reflection to the arguments of the principle in articulating the rights of the litigants. Legislative policy decisions create institutional rights which, of course, a court may enforce. But to secure a right based on the legislative policy does not mean that court's decision is a policy decision. Dworkin suggests in a recent article that a true counterexample to the right thesis would require a case in which a court determined the one litigant had the right to win, but as a matter of policy decided to award the decision to the opponent. Dworkin concedes that many cases are compatible with either an argument of the principle reading or an argument of the policy reading. However, Dworkin sees the compatibility of both types of argument with the cases as something of a victory for him. Since so many of his critiques adopt the policy reading as obvious, although it is possible to look at Dworkin's theory in various ways, this particular note will take the approach of understanding how these three phases of development in his theory evolved and changed while enriching his interpretive theory all the time, focusing on his developing critiques on Hart's work. Dworkin versus the major schools of thought in jurisprudence. Dworkin's original critique of Hart's model of rules in the concept of law revolved around the role of rules and the principles. In law, among the other issues such as role of custom as well as problem of judicial discretion and retrospection, it is clear that Dworkin found Hart's theory to be under-inclusive. This is due to the fact that as per Dworkin, Hart fails to take into account concepts beyond the rules, and thus his positivism is a model and for a system of the rules and its central notion of a single fundamental test for the law forces us to miss the roles of the standard which are not rules. In other words, by limiting the scope of the law to only rule that one can be identified by the rule of recognition, Hart fails to consider the role of existing body of the custom. For example, the royal assent and the other prerogative powers in the British legal system in law as well as concepts such as principles that can influence judicial decision making. While rejecting Hart's ruling theory of law, Dworkin also rejects the reasoning of the natural law theorist that there are a predetermined, absolute, and metaphysical moral principle which determines the moral standards upon which the validity of all human laws are based. He is also opposed to view that there is a necessarily a close link between justice and the law which natural law advocates. Dworkin rejects such as a propositions based upon the concept, the fact that law is such that its validity must not be derived from the justice it can deliver or the injustice. It is therefore possible to observe that Dworkin's place in jurisprudence is one where he is neither a natural lawyer nor is it possible to say he is a legal positivist, as he theoretically rejects some of the most common and basic views of the natural law theories, while also being very critical about the positivist. His theory thus provides students of the jurisprudence a theoretical form of the middle ground between the two theories. Phase 1 of the Dworkin's theory. One of the Dworkin's primary concern in the first phase of the development of his theory was to distinguish principles from the rule, as his theory hinged on the fact that Hart had only considered rules and thus the master rule of the recognition could not identify principles. He does this by saying that rules are applicable in all or nothing fashion, or rather, a rule is either valid or invalid, unlike principles, which do not apply to the cases quite so starkly. Principles have weight and dimensions. Thus, a principle may be taken into account while deciding a case but will survive as a principle even when it is overridden, as in the cases of adverse possessions, where the principles of no man shall profit from his wrong is overridden but not invalidated. This distinction between the rules and the principles introduced Dworkin's most consistent criticism of the conventionalist view of the law. According to the Dworkins, positivists maintain that in the certain hard cases where there is no pre-existing rule that governs the outcome of the case, the judge have a strong discretion to adjudicate and make new law. If this strong discretion existed, it would mean that the new law would act retrospectively, and the parties would be bound by the law that did not exist before their cases, as an unelected body of judges would be making the rules to fit the cases, and this would be undemocratic. Therefore, Dworkin rejects the concept of strong judicial discretion and with the distinction between the rules and the principles in hand, indicated that when adjudicating in hard cases, the judges invoke a legal principles and decide the outcome of the case accordingly. This distinguishes this concept of judicial reasoning from the positivist concept, as the positivist would argue that legal rules are distinct from the moral rules, whereas Dworkin is actually blurring the division between the two, as the principle can incorporate idea of fairness, justice and morality. Raz presented several counter-arguments against Dworkin's theory, although he accepted Dworkin's opinion concerning the issue of custom by modifying the Hart's rule of recognition. Raz, by using the Dworkin's argument against him, states that principles presuppose direct and guide judicial discretion. Raz also maintains that Dworkin has misunderstood the rule of recognition in that not only does this rule not recognize implicit law principles, it also does not identify explicit law either. Thus, the whole concept of the principle is not an issue. In response to these arguments, in the second and third phases of the theory's evolution, Dworkin modified and enriched some aspects of his critique while modifying other aspects from the first phase. Despite these criticisms, it is out of this discussion that Dworkin's one right answer thesis arose. Dworkin asserts that law clearly cannot be made up of rules only but also other standards. These include standards such as policies, principles, and the like. While these other standards are important and are effective as rules in the legislative as well as executive processes, they differ in character from the rules. However, rules, policies, principles together act as the what Dworkin calls the moral fabric of a society, which protects interest which members of the society regard as the valuable interest, which can be specified in the terms of right, such as the right to life, liberty, and the human dignity. For Dworkin, these rights and other rights valuable to the specific societies are particularly to each society and objectively demonstrate a certain type of morality which can be empirically determined to indicate what is important to the society and therefore should be protected by the law. This, therefore, is the argument which he uses to argue that morality does and should have some place in the law, particularly when determining dispute in the courts. It was also in this discussion that Dworkin's distinction between rules and principle was first discussed. For Dworkin, in a case where a rule applies, it does so in all or nothing method, fully resolving the dispute in the line with the rule which has neither weight nor the dimension and is valid because it is the law. However, where a rule does not apply and therefore a principle must apply, a principle is not as a conclusive as a rule. This is due to the fact that where a case has to be resolved by the application of a principle, several competing and contradictory valid principles may be applied, as a result of which the judge must weigh the principles against each other and apply the one which the judge chooses as being the best fit for the certain case based upon the full weight and dimensions of the various principles. Phase 2. In the second phase, that's in year 1970s, Dworkin reformulated and elaborated his original rules and principles, attack on the positivism in his right thesis, but he excluded the arguments distinguishing rule from the principles on the ground of weight and validity, as well as his attack on Hart's rule of recognition. In his formulated theory based on the right thesis, in which he discussed arguments of the principles, he indicated that these arguments of the principles are propositions of the political morality, affirming the existence of the rights of the citizens in a system of law, which can also be described as a seamless web of principles. He explains that if an issue already has not been covered by a rule, the judge in the case cannot exercise a Hartian mode of discretion and create a new law, but must give effect to what is implicit in the society's moral fabric, which is developed in the society within which the law and the legal system should operate. It follows, therefore, that the judge, like the superhuman judge Heraclius the Dworkin creates, must take into account the totality of the laws. So, legal sources have to be looked at, institutions, moral standards, and the goals of the society, and interpret all this in their best political moral light to achieve the appropriate fit, which will settle the questions with a single right answer. This holistic approach to the law is a further insistence by the Dworkin that judge cannot have a strong discretion, which seems to be the most consistent concept throughout the evolution of the theory and is partly carried over to the third phase as well. Raz criticized this theory as Dworkin distinguishes between source and non-source laws, in which he accords a separate private place to the legal sources which can be identified by Hart's rule of recognition. As Dworkin did not offer any rule of his own, Raz points out that Dworkin's theory, while refuting positivism, is basing some and arguably some of the most crucial of its feature on the positivism, which is contradictory. Despite the above mentioned critiques to the Dworkin theory, Dworkin at this point had managed to add his ever growing literature on the one right answer. In this part of the discussion, Dworkin postulates the concept of the super judge Heraclius, and the limits of the judicial discretion were further discussed in the light of this conceptual judge. As established above, Dworkin's arguments depends on the fact that where a dispute arises and needs to be adjudicated, a judge has a series of tools by which he or she can adjudicate, among which are the principles from the hard cases. Dworkin clarifies that there are various ways of resolving the dispute. There is also the right answer in each case with regard to this question: who has right to win? To answer this question, the judge will have to search through the moral fabric and decide how to apply the law in the best way possible. It is in this part of this theory what Dworkin explains the hypothetical judge Heraclius' role in his theory. Heraclius, as a super judge, with the great abilities of the analysis, deduction, and adjudication, would be able to justify the use of principle in hard cases by constructing the best theory of law possible. Such analysis will indicate that law is a seamless web of legal rules, legal principles, and other legal standards. And using this best theory, the judge would render a correct decision and justify it. For Dworkin, it follows, therefore, that even in the hard cases, judges do not have quasi legislative discretion. Rather, they may have a weak form of discretion which allows them to decide how and which rules of the principles to apply, but only if it is the right answer as far as it can be justified. He illustrates this somewhat hypothetical discussion on how to resolve the hard cases. In the case of Riggs versus Palmer in the year 1899, in this case, the question that arose was whether a murderer could inherit from the victim in a legal system where a testamentary succession clearly indicated that the beneficiary named in a will would always be entitled to inherit. In the absence of these rules, the court in the United States decided to apply the legal principles that no one should benefit from their wrongful action and denied the murderers the inheritance. For Dworkin, what this case demonstrated was that where an existing rule was clearly going to result in the wrong answer, the court used a principle to reach at the right answer, which had the same level of the legal validity as if the rule was used instead. In concluding remarks, over the years, Dworkin's initial critique of the positivism has been modified almost beyond recognition and has changed a great deal. However, the greatest change has occurred due to his adoption of the interpretive theory of law, as his phase of this theory has proved to be completely different from the first two phases, in that Dworkin has inadvertently accepted a great deal of the positivism in his critique of the positivism. Thus, in defining the purpose of this critique, however, the theories he has formulated are no less important in the study of jurisprudence, even if they have ultimately not been helpful to Dworkin in criticism positivism as one would expect. This is so because his approach involves a more fixed approaches to the legal theory. Neither major school of the jurisprudence, natural law and positivism is completely correct, nor are these schools completely incorrect, and in effect it is possibly to try to reject some parts of the theory while blending the other parts to have more holistic approach in jurisprudence itself. Thank you for the joining in this lecture. I hope it provided the valuable insights into the Dworkin's significant contributions to the jurisprudence. As we navigate the complex legal landscapes today, his emphasis on the principled reasoning serve as the vital guide. For further reading, I encourage you to explore taking right seriously and engage with contemporary critiques to deepen your understanding. So keep learning and reflecting on the role of law and principles in our societies. Thank you.